All right, let's dive into a topic that's pretty intense. It sits right at this complicated and honestly pretty tense intersection of law and human rights. We're talking about solitary confinement, and it's a practice that really forces us to ask some tough questions about punishment, safety, and, well, what it means to be human.
And this right here, this is the central question, isn't it? Is solitary confinement a necessary tool to keep prisons safe and in order? Or is it something that's just fundamentally inhuman? The really unsettling part is, what if it's both? Let's unpack that.
So what are we actually talking about when we say solitary confinement? You know, it's way more than just being alone in a cell. We're talking about complete, monitored isolation from pretty much all human contact. And this isn't for just anyone. It's typically reserved for inmates who are seen as a serious threat, not just to the public, but to the prison population itself. But what's the real human cost of that isolation? Well, the psychological fallout is severe. The sources all point to things like deep depression, a real loss of mental stability, and tragically, a much higher risk of suicide. It's for these exact reasons that the whole practice often gets described with one very powerful word: inhuman.
You have to wonder, where did this idea even come from? It's kind of wild, but it wasn't always seen as this incredibly harsh punishment. Its roots are actually in what you could call a kind of social experiment.
Believe it or not, if you go all the way back to the late 1780s, isolation was actually seen as a progressive idea. Seriously, the goal wasn't just to punish. The hope was that it would give prisoners this quiet space for introspection, to reflect on what they'd done and hopefully reform. But as you can see, the reality turned out to be a whole different story.
And this just lays it out so clearly, right? The massive gap between the hope and the reality. The hope was for quiet reflection. The reality, a total lack of human contact. The hope was that people would become better. The reality was severe mental breakdowns and, like we've seen, more suicides. The experiment, to put it lightly, did not go as planned.
Okay, so, given that history and the very clear dangers, how is a practice like this regulated today? Well, let's turn to India's legal system, which has actually tried to put some really strict limits on this loneliness.
First up, Indian law starts with a hard limit, 3. No matter how long a person's sentence is, could be years, could be life, the total time they can ever spend in solitary confinement cannot add up to more than 3 months. That's it. It puts a definitive cap on the whole thing. And even that 3-month cap is just the absolute max. As you can see here, the actual time allowed is scaled based on the prisoner's overall sentence. So if you have a shorter sentence, you get a much shorter maximum time in isolation. It's all about making sure the punishment is proportional.
Now here's another really critical safeguard. It's about how long you can be in solitary at one stretch. A prisoner cannot be kept in isolation for more than 14 days in a row. After that, a break is mandatory. And this is specifically designed to stop that severe psychological damage that comes from just unending solitude.
And the rules get even more specific for those longer sentences. To make sure that isolation doesn't become this constant rolling punishment, the law limits it to just 7 days within any single calendar month. This forces regular breaks and some return to human contact.
The law also demands some basic protections for a prisoner's well-being. They can't just be locked away and forgotten. First, their cell has to have some way for them to call an officer at any time. And second, and this is huge, if they're in there for more than 24 hours, a medical professional has to visit them every single day.
Of course, having laws on the books is one thing. How they're actually enforced is another. And this is where the courts have really stepped in, drawn a firm line to protect fundamental human rights, even for those behind bars.
This quote from a landmark case back in 1980 just says it all, doesn't it? The court's message was crystal clear. Because this punishment is so incredibly harsh, you can't just impose it on a whim. It demands a fair process with real checks and balances, like getting written consent and reporting it to higher-ups.
And as you look at these key judgments, you can see a really clear pattern of the judiciary stepping in. The courts have said, again and again, that solitary confinement must follow due process, that it can only ever be for a part of a sentence, never the whole thing. And most importantly, that it is subject to Article 21 of the Constitution, the fundamental right to life.
So after looking at the history, the laws, and what the courts have said, we get to the final balancing act. Is this practice, at the end of the day, a necessary evil?
And yeah, this really lays out the two sides of the coin perfectly. The justification is all about security, protecting other prisoners, keeping order by isolating genuinely dangerous people.
But that justification comes with a huge, non-negotiable condition. It has to be done legally, with due process, and it must always protect the constitutional rights of the prisoner. It's this constant tug of war between security and liberty.
Which leaves us with this final and, I think, really challenging thought. The law provides a strict framework that makes solitary confinement legal, but under very specific conditions. At the same time, the human experience of it is often described as nothing short of inhuman. So we have to ask ourselves, if a punishment can be both legal and inhuman, what does that really say about our system of justice?